Hi friend, today me and my friend Rajeshwar Panchal are going to discuss some of the important concept of arrest, which is very much important because it is touching the aspect of liberty of a citizen, liberty of a person who is going to get arrested, and who can arrest, how can the person be arrested, and what are the provisions in a nutshell, and what are the important judgments of the Honorable Supreme Court regarding this. First of all, the word arrest has not been defined anywhere, neither in the CRPC or nor in any of the subjects. However, what it means, arrest means deprivation of personal liberty of a person, or seizing the body of the person is called arrest. Normally, arrest can be done by police officers, we know. However, maximum people do not know that even arrest can be done by magistrate also, and arrest can also be done by a private person also. We shall discuss this later on. But first of all, in which offense police officer can arrest? In which offenses police officer is required to obtain the warrant from the magistrate? That is important. So the offenses are classified as cognizable offense and non-cognizable offense. We have to know what is cognizable offense. In a nutshell, I'm going to cover. A cognizable offense is such offense in which the police can arrest without warrant and can investigate the case without the permission of the magistrate. These are the serious nature of the cases, whereas non-cognizable offenses are small in nature, in which the police cannot arrest without warrant and cannot investigate the matter without the permission of the magistrate simply. Now I'm expecting some of the submission by my friend, discussion by my friend Rajeshwar. Thereafter we shall continue.
Yes.
One by one.
Yeah. Thank you, Shahid. Actually, the concept is that, the fallacious concept is that simply because you have been accused, and that too in a cognizable case, you must go to jail. This is what, people think of, but the exact law is not like that. And our Honorable Supreme Court of India has been stressing this point from 1994. Now, in the year 1994, a case came to Supreme Court. That is the famous case of Joginder Kumar versus State of Bihar. Now, in that case, what Supreme Court said, that offense is cognizable and you are accused. Okay. And therefore, it shall be lawful for the officer to arrest you. Now, Supreme Court has differentiated. Simply because it is lawful for the officer to arrest, it does not mean that he should arrest in each and every case. This is the first time that Supreme Court has, tried to curtail the power of police to arrest, because the power of police to arrest a citizen is a kind of lucrative business. Okay. And that empowers the police, and the arbitrariness, is writ large. Normally, we see the common man who is accused even in respect of a very not that much serious matter is immediately arrested. Okay, but at the same time, moneyed man, a political influential person may be accused in respect of serious crime, but still police will avoid to arrest him. So the victim or who is at the receiving end of the arrest power is normally common man. And therefore, to minimize this kind of arbitrariness in the matters of arrest, Supreme Court of India in 1994 laid down that simply because it shall be lawful for the officer to arrest, he should not go for the arrest, and he should try to carry out the investigation without touching the person, without effecting the arrest. And Supreme Court said it shall be in the interest of the police officer himself that arrest should be avoided unless it is otherwise necessary. So this is the view taken by Supreme Court, and the same view has been now reiterated in Supreme Court in the case of Arnesh Kumar. Now, in fact, Arnesh Kumar has become more famous because it is of late, and of course, in Arnesh Kumar, Supreme Court has gone ahead one step by saying that in all the offenses which are cognizable, but punishment is less than 7 years imprisonment. So in all such cases where a person is accused in respect of a crime or offense, which is punishable up to 7 years, instead of arresting automatically, there should be a procedure, and that procedure should be to issue the notice. And CRPC was amended to that effect, and now there is a separate section inserted into CRPC, that is section 41 capital A. Under that section 41 capital A, the procedure is like this, that even when somebody is accused in respect of a criminal offense, and that criminal offense is cognizable, okay, and non-bailable, so police officer may issue a notice to that accused, invite him or call him to the police station to remain present on particular date, time and occasion. And if such a person accused in compliance with such a notice remains present in the police station, then subsection 3 of the same article, section 41A says that then he should not arrest, he should not effect the arrest, because the presence of that person is secured by way of the notice. Now this very provision of 41A was explained and interpreted by the Supreme Court, and it is now made mandatory for the police officers to be followed in each and every case where offense is not punishable up to more than 7 years. So this is the latest view of Honorable Supreme Court. But even then, we see at the ground level, people hardly follow this kind of dictates of the Supreme Court. In our Maharashtra, in fact, the Director General of Police issued a notification, in fact, a circular, circulating these guidelines of the Supreme Court in the case of Arnesh Kumar to each and every police station in the state of Maharashtra. But despite such kind of circulars, the directives issued by the Supreme Court, we do come across the cases where police, arrest common people simply because they are accused, and that too in respect of the offenses which are not that much serious, and of course, not more than 7 years imprisonment. So this is the view, and in this regard, the action has to be taken against the erring police officer, as said by Supreme Court itself. Arnesh Kumar judgment categorically says that if any officer doesn't follow, even not only officer, police officer, even magistrate is also directed that they should not blindly legalize the arrest illegally done by the police, and they should not blindly ratify the arrest. And if that directive is not abided by either police officer or the magistrate, then Supreme Court has directed that let there be a contempt action as well as departmental action. And on similar line, the DGP circular also says. Now recently, you also might have heard, Telangana High Court convicted an officer who did not follow the Arnesh Kumar guideline. That case was taken to Supreme Court. Supreme Court also upheld that judgment, and that person was sentenced and convicted. His conviction under the contempt of court was, in fact, upheld. And recently, I came across another similar judgment from Delhi High Court. There also, Delhi High Court convicted that officer who did not follow the guidelines of Supreme Court in respect of arrest, as explained in Arnesh Kumar. So I think more and more people should, assert their right against the arbitrary arrest. We are initiating the proceedings against the police officer. What do you say? Hello.
Definitely, we respect the judgment of the Honorable Supreme Court. However, it is my observation that though the judgment has been delivered in 2013, Arnesh Kumar versus State of Bihar by the Supreme Court, still the police officers are reluctant and they are intentionally not following this judgment. Anyhow, they want to show that they are the king and they are the above the law, because they behave in a hooligan way with the common man, and they show that they are the only kings because they have power to arrest.
Yes. Now see,
power to arrest is one thing, and justification of the Supreme Court in this case. In Arnesh Kumar, the Honorable Supreme Court said that though the police have right to arrest, but it doesn't mean that they should arrest in a mechanical way, like a machine works. And the fact that the offense is only cognizable and cognizable offense has been committed, it means CRPC gives the right to arrest. But however, it doesn't mean that in all the cases police officers should arrest. They should apply their mind. They should justify the arrest, whether the person whether this will cause the hampering the reputation of the persons, because his liberty will be curtailed, whether the person is going abroad, whether his arrest will affect his personal liberty, whether
Yes.
he's in the job, whether he's a reputed person, etc., need to be taken into consideration.
Yes.
However, in habitual cases, the police can arrest. And in this case, the Honorable Supreme Court said that not only this judgment is applicable in 498A cases or
All
cases,
cases.
however,
Yes.
judgment is applicable in all the criminal cases which are punishable up to 7 years.
Yes.
And in this case, the procedure is laid down that
Yes.
police officer have to issue a notice
Yes.
under 41A, as said by my friend, and that notice has to be sent within the span of 2 weeks from the date of registration of this FIR, and
Yes.
the same duration can be extended by
Yes.
superior officer of the police. And once the notice is received by the person, then he has to obey. He has to remain present, not be arrested. And
Yes.
third thing is that if he does not arrest, he does not respect such a notice, then in that case, police officer may arrest that person.
Yes. Yes.
However, arbitrarily and whimsically, police officer cannot arrest. If he arrests, action under contempt of court can be initiated against him, not only against the police officer, but it is against the judges also, who being a guardian to safeguard the fundamental right of the accused, that is personal liberty. And the notices have been issued under this order to all the DGPs and the chief secretaries and the registrar general of the courts, so that the compliance would be ensured. And in case if the person gets arrested illegally without due process of law, then he deserves for compensation.
Yes. Yes.
As my friend has dealt with many of the cases under Compensation Act. So compensation. So you comment on the compensation point.
Yes. Yes. Now see why compensation is required to be granted in such cases is because, Article 21 of the Constitution mandates no person shall be deprived or no person shall be deprived of his life or personal liberty except according to procedure established by law. And the arrest is nothing but deprivation of your liberty. The moment you are arrested, your liberty goes, and therefore mandate comes into play that in every such case where somebody is being deprived of the liberty, the procedure of the law must be followed. And what is the procedure in India? That is what we are discussing. That in respect of the crime, where the offense is punishable up to less than 7 years, then the notice under section 41A should be given. If despite receiving such notice, accused doesn't appear before the police officer, doesn't remain present, then arrest may be justifiable. But without issuing such notice, if you arrest the accused, then you are not following the procedure established by law. And therefore, this would not be the case of only violating the CRPC or the mandate of section 41A, but this would constitute violation of Article 21 itself. And since it constitutes violation of Article 21, naturally you are entitled to claim the compensation as a matter of right. And this has become so, well settled the legal position, and that too particularly after the case of D.K. Basu. In the judgment of D.K. Basu, in fact, at that point of time, there was no such provision of CRPC, that is as today we have, that is section 41A. But despite this, Supreme Court had evolved some protective measures in the case of D.K. Basu to minimize the arbitrariness in the matter of arrest. And if any of the directives of Supreme Court in D.K. Basu is violated, then compensation will be mandatory. Now, in addition to what Supreme Court has said in the D.K. Basu, if we add what Supreme Court said in Arnesh Kumar to those guidelines, then naturally what must flow is the compensation. And not only compensation should be claimed, but apart from that, let me tell you one aspect, very important aspect. What Supreme Court says becomes the law binding upon everybody, even all the judicially subordinate judiciary in India, even including the high courts.
As per Article
Everyone is
141.
bound by the Supreme Court verdict, and that is because mandate of the Article 141. Okay, therefore, what Supreme Court says becomes the direction of law. And now there is a provision made in the IPC, section 166 of Indian Penal Code. Whosoever, being a public servant, shows any disobedience to the direction of law commits an offense. Similarly, now additionally there is section 166A. If the police officer doesn't conduct in a manner in which he should conduct according to the law or direction of law, then also he commits an offense. So arresting someone without following the mandate of Supreme Court, either in DK Basu case or Arnesh Kumar case or Joginder Kumar case, would straightway constitute not only the violation of Article 21, but also it would constitute an offense under section 166 and 166A. Apart from that, what Article 21 says is also the direction of law. Therefore, if any public servant violates or disobeys the direction of law, even including the direction of Article 21 of the Constitution, it will also come within the purview of the disobedience to the direction of law. Therefore, not only the compensation should be granted, but such officers should be prosecuted. And more the prosecutions in respect of such cases, more the judgment of Supreme Court of the law will be implemented in effective manner. Apart from that, these kind of police officers should be subjected to departmental action so as to invite the harshest penalty like dismissal or removal from service. Because these people, police officers, consider the liberty of common man very trivial issue. The liberty of common man is no liberty at all for them. Now, let me remind you one judgment of Allahabad High Court. We all must be aware that in UP, there is no provision of anticipatory bail. And
yes.
In the absence of the provision of anticipatory bail, the moment you are accused, the arrest was imminent danger. Your liberty was bound to be taken away. So many people filed petitions challenging the provisions by which the anticipatory bail was barred. In that, Supreme Court, the Allahabad High Court constituted bench of 7 judges, including the dynamic judge of Supreme Court, who later on became Supreme Court judge, that is Kadju, Markandeya Kadju. That judgment is the case in the case of Amravati versus State of UP. This judgment is also very dynamic judgment. In fact, rendered by the 7 judges. They have interpreted the provisions of CRPC. Even in the absence of section 41A, they have interpreted the CRPC that arrest is not mandatory. Arrest is only, when justifiable in the circumstances. Because law doesn't say, the provision of arrest, that is section 41 of the CRPC doesn't say that police officers shall arrest. It uses the terms like, it shall be lawful for the police officer to arrest. Okay. Now the words or the expression used by the lawmakers in the CRPC is not mandatory. It shall be lawful and the officer shall arrest. A tremendous difference. And this interpretation was done by Supreme Court in the light of the fact that once you are arrested, not only that you are deprived of the liberty, but you are deprived of your reputation. And reputation is very, very essential part and parcel of Article 21. Because, in number of judgments, in many of the judgments, Supreme Court has quoted one shlok from our Bhagavad Gita to highlight the value and importance of the reputation of a man, common man. Supreme Court says that for a man of honor, dishonor shall be worse than death. And that is exactly what Gita shlok also says. Now, in many cases where Supreme Court was dealing with the arrest, arbitrary arrest, the effect of the arrest on reputation, etc., so not only in that, even in the case of Lalita Kumari, what Arnesh Kumar says, what Joginder Kumar says, even in the Lalita Kumari case also, where the Supreme Court was dealing with the registration of FIR, but even in those matters, because the argument, one of the arguments advanced by the state was that if we registered the case, each and every allegation, in each and every complaint given by the common man, without carrying out at least preliminary inquiry, then it may result into illegal arrest or illegal detention. Then Supreme Court again clarified that it is absolutely wrong notion that simply because FIR is registered, it should not mean that you should arrest. So they again refer to what they said in the case of Joginder Kumar, that it is one thing that FIR is registered, you are accused. It is another thing that you are arresting. So in short, Supreme Court has been time and again highlighting the fact that arrest should be avoided, and without arresting, effecting arrest, at least in such cases where the offense is punishable up to only 7 years. And normally offenses which are punishable up to 7 years are not that much serious in nature. They are having a kind of personal kind of animosity, etc. And that is how this thin line has been maintained by Supreme Court, that these are the cases where arrest should be avoided, and the cases which are more serious in nature, which may have impact on the society at large, arrest may be justiciable, like murder, rape, that would be entirely different thing. Yes. So this is developing law, and it is our duty also as a lawyer that we should always stand to protect the liberties of the common man in whatever capacity that we can do. I think we should strive hard to maintain the liberty, because injustice anywhere is a threat to justice everywhere.
Yeah, I would like to add some of the lines in some of the paragraphs.
Yeah.
When a private person has the right to arrest the accused.
Yes. Yes.
Generally, we see that only police officer has the right to arrest.
Yes.
However, except lawyers and judges and private person can arrest.
Hello.
A person to whom powers have been given of persons. Private person can arrest only when the non-bailable offense has been committed by someone, or a proclaimed offender, often accused is declared as a proclaimed offender. In that case, person can arrest. That civilians can arrest that person. We call him that catching the person, nabbing the person, and thereafter handing him over to the police, and police will once again arrest. That will call re-arrest. So when a citizen helps the police to arrest, suppose a man is running after committing an offense, anybody civilians like us can arrest and seize that person and hand over him to the police station. That is called arrest by private person. That is covered under section 43 of the CRPC. It means it can be done only in cases of non-bailable cases, and only proclaimed offender can be arrested by private persons.
Now, not only non-bailable, in the light of Arnish Kumar judgment, when police officer himself cannot arrest, how come citizen should arrest? Okay, so now
that's correct.
Now therefore,
the judgment.
Otherwise, the private citizen who is effecting arrest,
generally, police generally common people, they do not apply their because they don't know their own rights.
Yes.
How they will do it, because they will not implement. Only a learned man like a lawyer or who knows the law can do it.
Yes.
In good faith, that should be done in good faith. And generally, it is my also observation being advocate that throughout the country, I have never seen that a judge has arrested a person. Have you seen any time? Because judge, they do not dare.
Yes.
Judge should actually, they should sometime dare. And magistrate has the right to arrest. That provision is given under section 44(1) of the CRPC. Yes. And magistrate, the word includes judicial magistrate as well as executive magistrate. Means like a Tehsildar also can arrest.
Yes.
When a magistrate can arrest, and in what situation he can arrest? He can arrest when the offense has been committed within his local jurisdiction, not in the outside of his local jurisdiction. Number two, that and the most important thing is that the judge can arrest in cognizable offense as well as in non-cognizable offense. Judge can arrest. He has got the more power than the police officer. But the problem is that police magistrate do not exercise this right, though the right has been granted to them. Another aspect which I would like to cover here is when a reasonable force can be used by police when a accused try to escape from the custody of the police. Sometimes we see that accused run away, he pushed away the police and he ran away. In that case, when When an accused is trying to escape from the custody, then reasonable force can be exercised by the police to arrest that or to nab that person. What is reasonable force? That has not been defined. That cannot be defined, because killing a person, killing an accused by chasing him doesn't mean that this is a reasonable force.
See, let me
So
tell you.
this depends upon the circumstances and facts of the case. Therefore, reasonable force means the force can be used. That should be a reasonable one.
Let me tell you.
Excessive force cannot be used by the police. Like arrested the police and he's ready to the station and court, then he handcuffed. You might have seen that, you might have read that there are also judgment that accused should not be brought in the court. And another important provision regarding arrest, that when a woman can be arrested, this is also important aspect, because Honorable Supreme Court has said that the woman cannot be arrested after sunset and before sunrise. And when a woman arrest them, and when woman should be arrested after sunset and before sunrise, then permission of the magistrate is required to be obtained, and only lady police officer can arrest after the permission is sought from the magistrate. And thereafter, you can also talk regarding the right of the accused. Once he gets arrested, what are the rights? We can discuss.
Yeah.
That's it. Yes.
So, but before that, let me tell you one thing. As you refer to use necessary force, use of necessary force.
Yes, yes, yes.
Section 46, I think, use power to police to use force whenever necessary.
42, 42, section 2, yes.
You know, this is one of the mostly abused provision by the police machinery, and using this kind of power, they indulge into killing the common man, and that killing of common man by the police is often styled as the encounter, and the encounters, the encounters, and then the as Hindi movies depict the manner in which they are carried out. Okay, and recently the government of UP was accused of having indulged into such kind of things in UP. And then so many petitions, PILs were also filed in Supreme Court against the government of UP. That around thousands of the encounter, more than thousands encounter took place during the last few years. So, and it is not only the UP government. In fact, all the governments will use this kind of thing. Even in UP also. Sorry, Hyderabad also. Before 2-3 years, I think one young doctor was raped and she was burned alive. Very next day, we saw in the paper that all the accused were shot dead. So this is very dangerous scenario, and this provision is one of the mostly abused provision of the law at the hands of police. Now coming to the rights of the accused after the arrest. Article 22 of the Constitution of India gives very basic human rights. When I am being arrested, I must know as to why, on what grounds I am being arrested. So my first right, that is fundamental right under Article 22, is that I should be told that for this reason I am being arrested, that there is this charge against me, that I have committed this offense, and there is such a complaint against me, and there is such a charge against me, therefore I am being arrested. This is the first right. Secondly, after I have been arrested, it is the duty of police to produce me before the magistrate within 24 hours without much delay. And this right to be produced before the magistrate within 24 hours of the arrest is also another very important aspect, very important right, because it is the magistrate that comes into play when I am deprived of the liberty for the first time. So the first court that comes in to protect the liberty of the citizen is the magistrate at the taluka level, and that magistrate is supposed to check out, examine whether the arrest is justifiable, whether there are reasonable grounds for the police to arrest me. But sadly, let me tell you, the magisterial courts of the country have not realized this duty cast upon the magistrate by the Constitution of India. And the Supreme Court of India had to tell in the case of Arnesh Kumar that they should not go on, giving the police remand or PCR simply because the police is asking for it. And if they do not go by the or abide by the judgment of Arnesh Kumar, they will be also subjected to the departmental inquiry. And I know one such case, Bharat Devdan Salvi versus State of Maharashtra. In the Maharashtra, the Bombay High Court had directed the inquiry against the Sections Court at Pune as. Just a minute.
Difficulty, like a technical issue.
Some network was.
The video got hanged. The video got hanged. Continue. You can continue.
Yeah. So our Bombay High Court directed departmental inquiry against Sessions Judge at Pune and Magistrate Court at Pune, who had not followed the judgment of Arnesh Kumar. It is not that what Supreme Court says always remains on paper. There are cases. Even judicial officers are also subjected to departmental action if they do not follow the Supreme Court judgment. Okay.
Yes.
So this is very important aspect of being produced before the magistrate within 24 hours, so that the magistrate will protect the liberty if it is illegally taken away. This is second very important right coming from Constitution of India. Now third right is that during the custody you are entitled to be consulted by the lawyer of your choice. Even during police custody, you are entitled to have the services of lawyer at your disposal, so that you can take the further course of action as to how to defend yourself. And then very important aspect is that you are entitled to defend yourself in the trial of your own choice. Okay. Now this provision has to be understood in the practical practical and feasible way, because it depends on your financial capacity to hire a lawyer of your choice. Okay.
Yes.
Simply because it is my right to have a lawyer of my choice, it doesn't
mean that he should be able to
subject to my, but in all those cases where I am not in a position to afford any lawyer, then it is the duty of the state to provide the lawyer from the free legal aid service. Okay.
Yes.
So these are the rights which are constitutional right. Okay.
Yes,
now these are the expressly given rights in the Constitution. But however, let me tell you, there are other rights which have been read into Article 21 by the Supreme Court of India or the High Courts of this country, judicial precedent. So one such right is the right to speedy justice. Speedy trial. It assumes more the value, because suppose you are subjected to accusation. Suppose you are accused of committing a crime, and the trial is prolonged for years together, and all these years you will be living with the accusation. Okay. People will be under impression that this is the person who is accused of so and so crime, and you will not be regarded as the innocent person. That is what society believes. So Constitution presumes you to be innocent until guilt is proven. Okay. This is also that you should be presumed to be innocent. Okay. Now similarly, not only speedy justice, you are entitled to fair trial, and fair trial would mean fair investigation, because the trial takes place on the basis of material collected by the police during the investigation, and if the investigation is not done fairly, then fair trial is impossible. Therefore, even accused is entitled to the fair investigation. Now, what kind of fair investigation? During the police investigation, material may come to the notice of police, and that material or that evidence will go in favor of the accused and prove that he is innocent. But police will not bring such kind of material before the court, because they want to acquire they want to procure the conviction at any rate. And this kind of this is called colonial attitude of the police. Because in the colonial British era, accused people were normally those who were fighting for the freedom, and they were subjected to prosecutions. So the police was always trying to obtain the conviction at any rate, and this colonial attitude continues even till date. Okay. Police are under impression that if somebody is accused, they should do hook or crook, but they should obtain the conviction from the court instead of putting whatever they have collected before the court. This would be, this would be the fair investigation, when police would place before the court whatever material comes, during the investigation. That material go to show the innocence of the accused or his guilt. So these are the constitutional rights. These are the very important rights stemming from our Constitution of India. One more important right, if you are arrested illegally, as we have spoken earlier, then these
Compensation.
okay. So these are the rights which are very, very important and very necessary to maintain the rule of law in the country. And let me tell you, recently, Delhi High Court had directed, in fact, it cannot be said to be a direction, but they had suggested Law Commission of India to make some scheme for the legislative protection for the compensation, because in India there is no statutory provision, there is no act of parliament providing the mechanism for the compensation. Like, in foreign countries, there are the statutes, there are the acts of parliaments of the state regulating the law regarding compensation, etc. But in India, there is no such law, even though we are party to the, our country is party to the international covenants on the civil and political rights, human rights. Okay. So now the Law Commission also recommended that there should be mechanism, but our parliament did not do anything further, according to my knowledge, at least to my knowledge. So these are the practical, realities. In fact, I just recall one judgment of Supreme Court in the case of Gujarat versus some Patel.
Yes.
Conviction. Conviction. In fact, one poor man was implicated by the police in the case of murder of a child, female child. And then while acquitting that person, the High Court had passed some strictures against the police as to how they have implicated this poor man. And then police shamelessly filed appeal in Supreme Court. So Supreme Court said whatever High Court has said, is beyond any doubt. In addition to what High Court has said, we will add to further point out that this man was implicated. Okay, but the poor man languished in jail for years together because he was denied the bail because of the serious allegation against him. So Supreme Court highlighted that this may not be the only case where somebody is being denied the bail, and because of that he is languishing in the jail years together. Okay, so Supreme Court has in fact dealt with possibilities that somebody is arrested, denied the bail, he remains in jail for years together, and then who is responsible? Whether we are in a position to give him back to what we have taken, that is years together of his life, and how long this will go on. So this kind of situation has to be remedied. Remedied matlab Supreme Court is itself saying that we should have the mechanism to provide compensation, and compensation may not be the exact,
State should have a budget. State should have budget for that. Like a welfare state should have budget in case violation of the.
We are claiming to be the welfare state. We must be held responsible if we have wrongly implicated somebody and taken his life. Okay.
Liberty. Yes.
So Supreme
Court. I would like to add some of the rights regarding this, and in my way, I would like to say what are the rights of the accused. That accused has a right that he should get the copy of the FIR. If the copy of FIR is not denied to him, then how he shall come to know what are the allegations against him.
Yes.
And as per the judgment of the Honorable Supreme Court, the copy of the FIR should be uploaded on the website within a particular time. Yes. That is actually this duty casted on the police officers. They are not fulfilling this duty in